When I'm reviewing the rights and ethics section of the grant application, I'm looking for a few things. First of all, I want to make sure that the applicant has a thorough understanding of the materials that they're going to be digitizing and what the legal and ethical issues are that surround those materials. I'm also looking for a willingness to open up materials as broadly as possible within the constraints of any legal or ethical concerns. Finally, I'm looking for applicants who are willing to provide very accurate rights information.
The analysis of intellectual property rights should be specific to the materials and not just a blanket statement. If the materials come from different sources or there's different types of materials, then the rights statement should have an analysis for each different type of scenario.
If applicants are interested or willing to use standardized rights statements through rightstatements.org, I think that's an added bonus because it does help users understand what they can or can't do with those materials. There are issues of privacy, there are other kinds of ethical issues, and these kinds of issues should particularly be considered when you're dealing with materials that were created by or about groups or communities that have been historically marginalized. In particular, for any project that's dealing with materials relating to indigenous nations or communities, thinking about cultural sensitivity issues is incredibly important. There are some good resources out there for doing that, and I would encourage anyone in particular who's working with Native American materials or other indigenous materials to consult the Traditional Knowledge Labels project to learn more about what some of those cultural sensitivity issues are and to work closely with the communities who are related to the materials in the project.
The first common issue is just a conclusory statement that there are no intellectual property issues. That very well might be the conclusion, but it doesn't really give me any idea of how the applicant arrived at that conclusion. So some analysis showing your work, showing how the materials were obtained by the applicant, and how you calculated whether these are materials in the public domain or you have permission to digitize and make them available is really helpful. The second common issue is a conclusory statement that all of the materials are in the public domain. That might be true, and you might be able to tie it to a very quick statement about the date that these materials were created. But oftentimes, in looking at the laws that are really complicated, there are differing analyses, whether it was published, did it have a rights statement. So having all of that information available helps me to understand the analysis that the applicant went through and to show that they really do have the rights to make this available to the public. Third common issue is when there are inconsistencies between the rights statement and the intellectual property analysis. Oftentimes there's a really good analysis, it shows good work, that we've figured out that some materials are in the public domain and you have rights and permissions to make them available otherwise, but then the rights statement says that the user has to figure out whether there's copyrights attached. As long as these two statements are consistent, it helps the users know when they can use the materials and how. The final common issue is a conclusory statement that there are no ethical issues when the description of the materials suggests sensitive information or that the materials were obtained from another country or involve children or some other materials that could be sensitive in nature.
There's a section on the application that really specifically talks about how projects that plan to use watermarks or charge fees may be looked on unfavorably. That is definitely the case. That's something that comes up in reviewer conversations. And so I would encourage applicants to really pay close attention to those caveats or those warnings that are given in the application guidelines.
It's always helpful when the applicant shows that they have sought legal advice or the advice of an expert on cultural sensitivity or copyright or issues specific to the jurisdiction where the materials came from.
One of the things that makes me really excited about an application is when there's some sort of added component or added outcome. This could be something like an unexpected partnership that could be a model for others. It could be a case where, in addition to broadening access, digitizing materials might help to preserve a threatened language. So anytime a project has that sort of unexpected or added component, I get really excited about that application.
I'm most excited to see when an applicant is passionate about their materials and they want to make them available to the broadest audience with the fewest restrictions.